Hi everyone, we are commencing the session in a minute, so we request everybody from the 6th floor lounge to make their way to the auditorium. Good evening, distinguished guests, ladies and gentlemen. It is my privilege to welcome you to this very special session of the Delhi Arbitration Week 2025. To those who have been with us through the day, welcome back. To those joining us for the first time this evening, we extend a very warm welcome. We now begin session 4 on a subject that sits at the very heart of the contemporary arbitral practice: investment arbitration at a crossroads. Key developments, emerging trends, and future directions. Investment arbitration has always reflected the interplay between law, economics, and international relations. What we see today, however, is a moment of particular inflection. Treaty frameworks are being rewritten, states are reassessing sovereign space, and the legitimacy of the systems itself is under sustained scrutiny. At the same time, global investment flows demand a dispute resolution mechanism that is predictable, efficient, and fair. As we stand at this crossroads, it is crucial to examine where investment arbitration is headed and what role it will play in shaping global commerce and governance in the decades to come. To guide us through this important discussion, we are honored to have an eminent panel of speakers. Our esteemed chair for this session is Honorable Mr. Justice Sanjay Karol, Judge of the Honorable Supreme Court of India. Justice Sanjay Karol hails from the village Garli, the first heritage village of India, Himachal Pradesh. He was appointed as the Advocate General of the state of Himachal Pradesh in 1998 and served in that capacity till 2003. He was conferred the designation of Senior Advocate by the full court in 1999. He was then elevated as a judge of the High Court in 2007. He served the court for a period of 11.5 years, including over a year as the acting Chief Justice. Further, he was the patron-in-chief of the Himachal Pradesh Legal Service Authority and the Chancellor of the Himachal Pradesh National Law University. Before his elevation to the Supreme Court in 2023, he served as the Chief Justice of both the Patna and Tripura High Courts. Justice Karol is widely respected for his scholarship and his judicial leadership. His judgments reflect a deep engagement with constitutional principles, commercial jurisprudence, and cross-border legal issues. Justice Karol has consistently emphasized institutional strengthening and has been a strong voice for reforms in dispute resolution. We could not have envisioned a more distinguished chair for this session. Please join me in welcoming Justice Sanjay Karol. Our first panelist is Honorable Mr. Justice A. Muhamed Mustaque, Judge of the High Court of Kerala. Born in Thana, Kannur, Justice Mustaque earned his law degree from VB College of Law, Udupi. He enrolled as a lawyer in 1989 and practiced for 7 years in Kannur before pursuing advanced studies, including a master's in space and communication law from Paris University, private international law course at the Hague Academy of International Law, and advanced courses in e-commerce and intellectual property from WIPO. He has extensive experience as a litigation lawyer, arbitrator, and mediator, serving as standing counsel for Kannur University and representing various institutions, telecom companies, and local authorities. Justice Mustaque has numerous international publications. He has participated in global conferences and contributed to professional training and mediation programs. He has held key roles in professional organizations such as the India International ADR Association and the Mediators Council of India. He was sworn as the additional judge of the Kerala High Court in January 2014 and became a permanent judge in March 2016. Justice Mustaque was appointed as acting Chief Justice of the High Court of Kerala in 2024. Drawing on his experience and his groundbreaking work in mediation and legal services, Justice Mustaque's insights today on modernizing dispute resolution and promoting access to justice will be absolutely invaluable. Please put your hands together for Justice Muhamed Mustaque. We're also privileged to have with us, and let me try and pronounce this correctly, Professor Dr. Laurence Boisson de Chazournes. Professor de Chazournes, a distinguished arbitrator at Matrix Chambers, is a globally renowned authority in international law and arbitration with an illustrious career in dispute resolution, public international law, and environmental law. She currently serves as president of the Council of the Center for International Dispute Settlement and was the director of the MIDS LLM program until 2024. She is a member of the Institute of International Law and the Curatorium of the Hague Academy of International Law. She previously served as senior counsel to the World Bank and has been a professor and head of the Department of Public International Law at the University of Geneva. She has also taught as a visiting professor at leading universities worldwide and delivered guest lectures across multiple continents. As a practitioner, she acts as the arbitrator for ICSID, ICC, PCA, SCC, and CAS, including serving at the 2018 Winter Olympics CAS Ad Hoc Division and as a judge at the BIS Administrative Tribunal. She has chaired WTO arbitration panels and appears as advocate and counsel before the International Court of Justice, International Tribunal for Law of the Sea, and other international dispute forums. Her contributions to academia and legal practice as a professor at the University of Geneva and a prolific scholar have influenced the global conversation on fair and efficient dispute resolution. Today, we're honored to hear Professor Chazournes' priceless advice on promoting excellence in international arbitration. Please give a huge round of applause. Our next speaker is Mr. Pramod Nair, Senior Advocate. A graduate of NLSIU and a postgraduate from the University of Cambridge, Mr. Nair comes with a wealth of expertise in international commercial and investment arbitration. Mr. Nair is admitted both as an advocate in India and as a solicitor advocate with higher rights of audience in England and Wales. A prominent figure in India's legal community, Mr. Nair is well known for his proficiency in complex litigation, corporate law, and international commercial arbitration. Having practiced for decades, he has successfully managed high-stake cases in industries like technology, infrastructure, and energy, gaining a reputation for sharp advocacy, strategic acumen, and a global perspective. He has represented India in arbitrations commenced under BITs and has also represented India at the United Nations. His contributions are not limited to the courtroom. He is a respected voice in the legal community due to his thorough knowledge of cross-jurisdictional issues and dedication to promoting effective dispute resolution. Please welcome Mr. Pramod Nair with a huge round of applause. Our final panelist for this afternoon is Professor Joongi Kim, Professor of Law at Yonsei Law School, Seoul, Korea. A court member in the ICC, he has acted as an arbitrator under the rules of GGGI, HKAIC, ICC, ICSID, JCAA, to name a few. In 2019, he was selected as the International Arbitrator of the Year by the KCAB International and the Korea Economic Daily, and received the Top 10 Arbitrators in Asia Pacific Award by the Bali International Arbitration and Mediation Center. He also sits on the editorial board of several international journals of dispute. His research focuses on international arbitration, international trade and investment, corporate governance, and good governance. His treatise, International Arbitration in Korea, received the 11th SIMDAG International Trade and Business Research Award. Professor Kim is a well-known researcher and advisor whose work has had a big impact on how arbitration procedures have evolved in Asia and beyond. We are privileged to have Professor Kim to share his valuable perspective. Please join me in welcoming Professor Kim. With such a distinguished panel and an issue of such contemporary significance, this session promises to be engaging, thought-provoking, and forward-looking. It is now my honor to invite our chair, Honorable Mr. Justice Sanjay Karol, Judge of the Honorable Supreme Court of India, to lead this session. Please put your hands together for Justice Sanjay Karol.
A very good evening to one and all present here, on the dais and off the dais. My special pranam to my mentor, Justice Sikri, who's there in the audience. Surely he has been a mentor for most of us who are here, who have been in Delhi, who have been in Supreme Court, be it on this side or on that side. I come here and speak not in my capacity in which I have been called, but only as a student of this branch of law. And therefore, I'm going to express freely. Today is the 6th day of the Delhi Arbitration Week 2025. 27 sessions, 135 distinguished speakers. I must compliment Justice Prasad and his team. And more than that, the ones who are present here have not allowed the fatigue to set in their mind or their body. Compliments to you. It is my privilege to be here and speak on the topic investment arbitration at Crossroads, key developments, emerging trends, and future directions. The theme we explored today could not be more apt of our times, which are passing through an era of unpredictability in the social, economic, and political spheres. If I may begin with a brief journey through the history of the world, if we were to say, is essentially a fight between rule of law and rule by the law, akin to rule by force. Professor Dicey, in his seminal work, Law of Constitution, has laid down basic principles identifying the components of the former. Whereas for the latter, we need only to turn the horrors of the past in Germany and Japan, which require no elaboration. The way the legal system of the country is structured depends heavily on the type of polity it has adopted. Whether a nation is a democracy or a dictatorship or a monarchy impacts the way investors, especially foreign investors, perceive these nations as a destination for friendly investment. In a democracy like India, we have the Arbitration Act, and we have Section 45 and 50 of the said Act, which is with regard to the enforcement and refusal of the enforcement of foreign awards. As such, the domestic statute, despite its alleged limitations, has attempted to clearly carve out the areas of appeal on the contours of recourse permissible. This is the position which parties have consciously opted out of the mainstream legal system and taken the arbitral route. We have emphasized repeatedly minimal judicial intervention, and that is the order of the day. I must also say this, that I had an occasion to summarize the law of scope of interference available in the courts in India in Sundaram. And this is despite the majority view in Gayatri Balsam, of which I am of the view that the judgment must be taken in the pro-arbitration perspective and not in any way as an encouragement to courts to set aside awards without just cause. World over, we have various models of arbitration laws. The UNCITRAL model law is a legislative template provided by the United Nations Commission on International Trade Law of countries to modernize and harmonize their domestic laws pertaining to international trade. These model laws, the most well-known of which is the UNCITRAL model law on international commercial arbitration, provides a comprehensive framework of rules and provisions aiming to facilitate and promote international trade and commerce by the establishment of consistent legal standards across different nations. The other model, which became a legislative template for many countries across the Commonwealth, was the English Arbitration Act and, of course, the new Arbitration Act of 1920-25. I will touch upon the bilateral investment treaties a little later, but let me turn to the country with a different structure of polity. For instance, in a monarchy like UAE, arbitration is the UAE is regarded as a federal arbitration law of 2018, which is largely governed by the UNCITRAL model law amended in 2006. Interestingly, UAE law permits offshore courts to abide by the federal arbitration law, but in order to incentivize foreign investments, the Emirates has created two other parallel regimes for the Dubai International Finance Center and the Abu Dhabi Global Market. To draw a parallel from India, DIFC and ADJM, which I just recently referred, may be termed as special economic zones which provide investors certain benefits, such as tax relief and simpler business regulations so as to attract maximum foreign investment. In the DIFC region, the arbitral proceedings are governed by the 2008 DIFC arbitration law, whereas in the ADGM, they are governed by a different procedure. Even an extremely different polity, such as the neighboring Myanmar, has chosen to follow suit, largely adopting the world model of UNCITRAL. The origins of what we today call is investment arbitration lie in the aftermath of the Second World War. As nations rebuilt their economies from the rubble of war, there was a surge of foreign investment, but also anxiety. Investors feared that these assets could be nationalized or subjected to arbitrary state action. States, on the other hand, wished to attract capital, but without giving up their sovereignty. To bridge the tension, BITs began to be signed. United Nations Trade and Development takes note of BITs as agreements between two countries and that establish the terms and protections of the private investment by nationals, companies of one country inside the territory of the other. These BITs aim to promote cross-border investment by reducing political and legal risks. Germany and Pakistan concluded the very first BIT in 1959. What followed was a proliferation. By the 1990s, hundreds of such treaties came to be signed across the globe. Parallelly, in 1966, under the aegis of the World Bank, we had the International Center for Settlement and Investment Disputes, which was established. The ICSID provides a neutral forum where investors and states, both alike, would resolve disputes without the political overtones of diplomatic protection. This institutionalization of investor-state dispute settlement, or ISDS, gave confidence to investors and encouraged cross-border capital flow. Resultantly, by the early 2000s, it had become one of the defining features of international economic law and was witnessed exponential growth for the past 3 decades. The numbers tell us their own story. As per the data from ICSID, there are about 1,000 known cases globally and about 2,222 through international investment agreements and 390 with investment provisions currently in force. Thus, the total of 2,612, which is by no stretch of imagination a small number. The UNCTAD estimates recorded exponential growth over the last 30 years, with every day, passing day, the numbers increasing. However, significantly, the stakes involved are colossal. The current outstanding amount of damages involved in investment arbitrations is roughly around 141 billion crores in Indian currency, or 1.6 billion US dollars, which is by no stretch of imagination small. If we look at the figures for disputes sectorally, as per the ICID's case load statistics of 2024, key trends and insights, we find that in oil there were 38%, mining 10%, construction and infrastructure 12%, and financial sector 15%. Region-wise, Latin America continues to generate cases in mining and extractives, and Colombia, Peru, and Mexico among the most frequent respondents. African origin disputes are generated in oil and gas and mining projects in countries like Nigeria, Tanzania, and Democratic Republic of Congo. The Asia-Pacific region is emerging as a new hub, not only in traditional sectors such as construction, but increasingly in digital economy disputes, particularly involving data localization, e-commerce restrictions, and fintech regulations. I would also say this, that as we see today, today we are not just legal disputes, but questions that strike at the very heart of public policy and national budgets. To date, 132 countries across the world and one economic grouping are known to have been respondents in one or more ICDS claims. The system's growth reflects its initial success in creating confidence for foreign investment. However, we are witnessing concerning retrograde trends. A legitimacy crisis has emerged. Pardon me for saying so, but this is the truth. Investors want and demand predictability. States want and assert flexibility. How much space should a sovereign state retain to respond to changing priorities, whether in climate change, technology regulation, or public health, are the issues which I'm sure would be deliberated in this conference. And how much protection must be guaranteed to investors who bring in long-term capital is something which needs to be examined. These priorities shift, differ, and vary from country to country and government to government, but span across arenas encompassing and interlinking social and economic policies. Yet, at the core of this tension lie contradictions. These have led to several nations withdrawing from investment arbitration frameworks, reverting to domestic courts. This movement gained particular momentum following high-profile cases and substantial awards. For instance, countries like Bolivia, Ecuador, and Venezuela have withdrawn from the ICSID convention entirely. Albeit, it can be argued what these withdrawals also have elements of political undercurrents which are beyond the scope of deliberations today. Specifically, in the Indian context, I would say that we have unveiled a new BIT model. It introduces stricter definition of investment, narrowed the fair and equitable treatment clause, and required investors to exhaust local remedies for 5 years and before turning to arbitration. Only a handful of countries ended up signing this treaty. But now we are at crossroads. What do we do? The emerging trends. I'll now deliberate on that. Certain emerging trends, however, stand out, reshaping the landscape and investment arbitration. The UNCITRAL Working Group 3 has been working on procedural reform of ICDS system. This forum has become the epicenter of the reforms. Some proposals under active consideration include setting up of a multilateral investment court, a permanent body, perhaps, a draft code of conduct of adjudicators to address the concerns regarding the conflict of interest, repeat appointments, and lack of diversity, and also the advisory center or establishment of an advisory center on international investment law, inspired by the WTO, Advisory Center of Law. The consideration of these reforms, according to me, reflects a sobering recognition of the fact that legitimacy deficit in ICDS cannot be ignored and must be tackled comprehensively. The European Union is the primary votary of these measures, whereas the United States of America and Japan appear more keen in adopting an incremental steps. These countries prefer reform within the traditional ICSID and UNCITRAL regimes. Japan and the USA, for now, are maintaining that party autonomy, and preference should not be easily interfered with. The position of other countries and regions remain ambivalent, more or so as of now. While traditionally a trade forum, the WTO has begun engaging with the idea of investment facilitation for development agreement. It seeks to enhance transparency, streamline administrative procedures, and ensure fair treatment for foreign investors. Then there is a looming figure of regulatory chill. It is no more a secret that climate change reforms have been slowed down by states such as New Zealand and Denmark. To name a few, fearing potential claims from current investors, which would entail liabilities running to billions of dollars. New technology has also a unique role to play. Technological aspect will be governed by my esteemed colleague, Justice Mustaque, in his presentation. But I may just only touch new sectors like cryptocurrency, fintech, data governance, artificial intelligence are already becoming sites of investment and potential dispute. Legal questions such as how do we value an expropriation is in a rapidly shifting technology market. Can AI be used in the arbitration process itself? And if so, how do we ensure fairness? These are questions which I'm sure would be deliberated in the conference. They're bound to rise. Concerns remain, though, as a few countries in Latin America, including but not limited to Bolivia and Ecuador, remain outside the ICID. And some EU states are exiting or seriously contemplating to exit from the ECT, which over the years has been used by investors to sue states over climate-related policies, leading to the proverbial environment versus investment debate. I may illustrate, climate change-based related claims are also being raised in greater numbers. For example, in the judgment of Taura, The investors marked as 60 million euros, which have been challenged by the Slovene coal phase-out policy. These cases arise core questions of proportionality. What measures taken to mitigate climate change disproportionately interfere with or impede investors' right, and applicability of the legitimate expectation of in principle of the investor. In simpler terms, arbitral tribunal can, when it finally decides, will be called upon to delve into and answer whether these issues can be compensated or quantified in monetary terms. Another example, in the case of Ascent Resources, where the investment, United Kingdom-based investor, mounted to 656 billion euros against the claim, alleging that its fracking ban was discriminatory and targeted specifically at the said investor. Yet another example is the Guinex Metals case, where the claim is of 435 million pounds against the Poland government. Moreover, Latin American bloc, as also the African nations, are trying to develop their own arbitral institutions to reduce dependency on the existing institutions. For example, Freshfields, in its recent publication titled Shifting Grounds, the Trends of Reshaping International Arbitration 2025, has identified organizations for the harmonization of business law in Africa, commonly known as OHADA, in West Africa, as an emerging regional hub for such arbitrations. In India, the Ministry of Finance announced earlier this year, in 2025, that they have they intend to come out and have a draft of the new model of DIAC, which I guess by the end of the year or in beginning of the year would be placed before the Parliament. Taken together, these trends demonstrate that investment arbitration is not static. It is, if I may borrow the phrase, in motion. Whether it moves towards reform, integration, or fragmentation, that is what we must carefully examine in the years to come. Indubitably, the Parliament of the Government of India has been alive to the need of reforms. And as I mentioned earlier, that now new BIT is there and should be tabled soon. And it is all this only for ensuring doing ease of business. That's about all. While I must also say that the Supreme Court, Indian Supreme Court, had previously upheld and rooted emergency arbitration in the Indian law by way of pronouncement in Amazon, but the amendment bill gives a statutory clarity to the same. Further, with a view to iron out procedural issues, India has made a progress in all measures, and be it amendment of the statute or the judgments which we deliver. Both pre and post award, the bill has proposed, in this case, the bill has proposed two versions of text to define seat and venue in section 20. The bill also draws inspiration from the global best practices of institutions such as the Singapore International Center. Keeping pace with the times, arbitral reforms in India are also concurrently focusing on the amendments in different statutes, the Companies Act, the Bankruptcy Code, and this is all to have in sync with one object and purpose: ease of business in India for any investor in any sector. When we speak of future directions, we must focus not on what is desirable, but also on what is achievable. Enforcement has become the Achilles heel, if I may use that expression. As I mentioned earlier, statistics tell us that even today, approximately $1.5 billion US remains unpaid in arbitral awards worldwide. When we look at the arbitration, often we conceive the process as ending with the pronouncement of the award. However, the winning party is still left with the daunting aspect of enforcement of the same, which is why it does not surprise me that most participants of the survey wanted the government to work towards simplifying the enforcement of the awards. However, as the courts have also acknowledged, that bottlenecks persist in the execution and enforcement stages. What this means is simple. Investors who have prevailed in arbitration are still left empty-handed, while states are locked in enforcement battles and drag on for years. This weakens confidence in the system. And after all, what is the value of a favorable award if it cannot be realized? The state also needs to have an appropriate mechanism. When I'm using the expression state, I mean all nations of the world, to raise counterclaims if and when required. Earlier, states' counterclaims were more seen as defenses to claims and treated in that fashion. But recent tribunals have moved to examine the adjudication of some counterclaims as opposed to rejecting them outright. So there is a positive change even in that aspect. I would say this, that undoubtedly the state will also guard their sovereignty and women's. Investors will always seek predictability and continuity. The challenge always lies in finding a middle path. Future treaty drafting must, in my view, provide clarity on standards like fair and equitable treatment. Recognize the legitimate right of the states to regulate in public interest, especially for climate change, health, and technology, but also ensure investors are not left without effective remedies. A balance must be struck, one that marks investments arbitration not a zero-sum game, but a platform mutual trust. There are some battles which have to be fought, and perhaps rightly so, perception-wise. While justice must always be done to adopt from our revered jurisprudential doctrine, but it also must seem to be done. What experience demonstrates is that treaties, agreements, and contracts need to cover all possible consequences and issues one can reasonably contemplate, such that the investor and state both know their respective rights, duties, obligations, as also the recourse each party has if the other defaults. History has shown us that international law evolves not in straight lines, but in cycles of change, reform, and investment arbitration is no exception. Today, we find ourselves at the crossroads worldwide. One path leads to disengagement and fragmentation, the other reform and renewed legitimacy. We have our distinguished panelists here who would be expressing their views on different topics. I shall not speak any further, but only say this, that the Chief Justice of Delhi High Court was here, I met him. The judges of the Delhi High Court, not only arbitration, mediation, conciliation, by whatever name you may call it, it's close to my heart. And to demonstrate that, I have won the tie given to me by the Mediation Center at Delhi High Court. Thank you very much, please.
Thank you, sir, for your insightful address and setting the tone for the rest of the discussion. Now, please join me in welcoming Honorable Mr. Justice A. Muhammad Mustaque, who will address us on the topic Use of Technology in ISDS. Please give a huge round of applause to Justice Muhammad Mustaque.
Honorable Chair, my co-panelists, Brother Judge Anand Bangladesh. When I see him, I get a fear inside. Many may not know. He sent me out of the ground of IIT ground of Madras. On the first ball, he hit on me in my forehead. So I carry that mark of respect on future stitches on it. So that makes a feeling that I'm in a night watchman in a slow verse. So you don't expect much from us in a brainstorming sessions you already had. Well, particularly I choose this topic, use of technology, since I'm working in my parent high court as a committee chairman of computerization for the last 5 years, the chairman. And I thought I extend my experience into how it could, one field encountered in when there's use of technology in ISDS. Yes, in the past 19 years, I think almost 19 years, an Indian judiciary is working a transformation to using technology. Except the changes you see in the High Court of Delhi, the people use some very good hardwares. What changes is brought? We need to introspect ourselves why we can't bring a change in the judiciary and where we have failed. I'm not saying that we have failed, what we could not achieve, what is we desire. Almost 19 years we are working on it. In the UK, it's all started in 2016, and many other countries in the globe started much later than our country initiated. But still, we have a problem. That exactly if we borrow the words of Albert Einstein, we cannot solve our problems with the same thing we used when we created them. All the rules and procedures have been set in Indian judiciaries to cater the requirement and the physical ambience of dispute resolution in adversary litigations. The rules remain the same, but we try to create a digital space with the same rules which operate in the physical world. That's exactly the problem. We try to bring many changes. We thought it's a problem of software, but later it's found out it's not a software's problem. We thought it's a problem of mindset of our judges. That is not the problem exactly. Some judges are willing to work, but if we create an ambience, and if it's inescapable for every judges, they are bound to work in that ambience. But nothing is happening at the ground level. In my home state, of course, I could achieve something by creating a e-filing module, which is different from other states. But nothing is in ground, is in the transformative level has happened. It is exactly the reason that we work with the same mindset, we work created for ambience in the physical settings, and we try to create a digital space. Instead of focusing on transformation altogether using technology in different level and different layer, we may not be able to achieve what we are intended to achieve through use of technology. So we had to start from the clean state of mind and not simply aping or embracing in a physical infrastructure for which all the rules and procedures have been created. If New York Convention could be a defining moment for global arbitration, so also the ancestral model rules, why not we create a new set of rules for ICDS or in international arbitration or in stress arbitrations? And that's where our thinking or our thought process has to lead us. Merely embracing the technology and relating to our work, I don't think it will bring a transformation. The transformation happens not by lateral thinking, but on the basic and fundamental approach. History has witnessed that. Only when we face the challenges comes to a different form and in different ways. But unless we adopt an I value principles and a principles with higher than what exists, we may not be able to bring changes. To bring a changes, we need to think alternatively or differently and not in a beaten path. So that's exactly the Einstein's book. We cannot solve our problems with the same thinking we used when we created them. That is equally applicable for any transformative theory. When you look at ICDS and digital era, need for reforms, the legitimacy crisis, the inconsistencies in ICDS rulings, time-consuming and expensive, lack of transparency. The legitimacy crisis, yes, when there is a change of guard of the government, you find there's conflict. Investors' interests need to be protected. At the same time, the public interest of the sovereign country also need to be protected. How to have a fine balancing of these principles? What are the principles which would govern us? What are the super norms that could international bodies or the other bodies can evolve? The legitimacy crisis affects in a different way. There are cases now come up where the arbitrator who became part of it, the ICDS dispute, appears as a counsel in different jurisdiction for the same parties. This goes to the very root of the legitimacy of such arbitrations. The algorithm, of course, like not a human mind, though it can carry a bias, but it can be as neutral and impartial if we have a supervised algorithm, a model. The inconsistencies in ICD's rulings, the time-consuming expenses, they do not need to be explained, the lack of transparency. So we need to think of use of technology, not to fix certain issues we face, but to create a new environment, a new ambience. Maybe these are something which is quite useful in present environment. Choosing having arbitrary selections, case prediction, it's possible. Evidence management using blockchain technology, yes. Case management system, fixing timeline, textual and speech search, of course, it's all possible. You all know that transcription, translations, all are useful. The fixing timeline, yes, it has been to certainty. And I did my NCMS work for the Supreme Court, where one of my suggestions is to fix timeline. Algorithm can fix timeline, taking out the complexity of the cases, number of witnesses, and taking out of the total load of that case. So the algorithm can fix a timeline. We need not rush with an outcome merely because the people are in the queue. We can fix a timeline. Algorithm can assist us in fixing the timeline. The transcription, translation, all you know, how we all use the different AI tools. These are all possible. These all supplement our needs in the physical world. But that itself cannot resolve the basic and fundamental issues which we face. Again, in using the AI tools, we may face a lot of issues like privacy, especially in countries in European regime. There is this robust data protection laws from 95 onwards. And that issue depends. We have an issue of using compass in the USA because of its inherent bias shown against black community, ethnicity, in application of sentence reforms or recidivism. And that came in as a critical across the globe because it's shown some bias, though ethnicity is not a matter in sentencing policy in the US. The compass is a glaring example showing the bias of AA. The black box problem, again, the internal decision of large LLM model. Nobody knows. These are some of the challenges. Of course, we can overcome. I'm not speaking against use of these technologies, but we can overcome these challenges. Bias and limitation of understanding human nature, obvious. AI or technology cannot replace human mind. The ultimate justice should come as a virtue and a value from period of Greek. The attempt to define justice on the value based on an understanding of human virtues. The justice system and jurisprudence evolved from centuries to test upon those values. It is impossible for technology to replace human mind as a judges, but still it can assist us in a way to minimize our work, especially in the volume of evidence and volume of documents involved in a process. There can be another layer of issue, defining digital assets. This has become a big challenge in the international scenario, and especially international investment disputes. And Salini versus Morocco given a definition and attempted to define it, how a digital asset, what does constitute a digital asset, whether trademark intangible assets would constitute an asset investment or not. And this definition would give a clear example, what constitute a digital asset. So intellectual property rights, yes, sometimes it becomes problematic, state in defining it. So in Salini versus Morocco, it has been defined, even intelligible intellectual property rights also constitute an investment if it is promote the economic interest of the host state and it involves risk. Again, there is an area of problem in use of technology, especially we know the problem of the digital address is spread across the cross borders, and defining jurisdiction and identifying the costs leading into the disputes. The Salini test, which I mentioned here, then the ongoing dispute is Hon'ble versus and GSA versus Canada, where the issue is simple, where the seismic data owned by the company, GSI, but through the regulations of the Canadian regulations, allowed to be exploited without a compensation. So regulatory schemes in Canada allowed appropriations of the data. This led to the disputes. Question is that those data is an investment, can be considered as an investment or asset, and that dispute is going on. This is another challenge which we may face, defining jurisdiction. Of course, model law, based on model law, most of the information technology laws in the countries, of many of the countries, have followed it, apart from the jurisdiction over the persons and the computer system. It has also prescribed extraterritorial jurisdiction. Even our country's laws and the information technology laws allows for extraterritorial operations. This is another issue, which of cyber warfare. The state responsibility international law, of course, it's part of the customary international law. The warfare and the Tallinn is a manual, is a compendium of all the laws related to the cyber warfare, and the academics and experts to bring it as a one document which to guide us to the rules and laws to be followed. But the customary part of the international law, state responsibility, of course, demands in every state to protect its citizens, not only its citizens and outside, by taking measures to prevent any cyber warfare or cyber attacks. So this is another challenge in the use of technology, and it is a challenge in relation to any other investments in the host city or host state. So the Tallinn manual gives an idea how the international law responds to such challenges. So these challenges gives an idea how things are shaping in this era. Both in aspect of related to procedural aspect of arbitration or settlement disputes, as well as substantial law relating to the investment. Now, why we need a new system in the place is obvious. These issues we may experience cannot be responded with the laws which we follow in this physical ambient. That's as simple as that. So globally, many have started thinking in this line. The guidelines have come. The Silicon Valley arbitrations, mediation centers, they issued certain guidelines. The trend is now is coming up in such a level to embrace the technology for not only the procedural matters, but to address substantial issues that likely to arise in those dispute mechanism. So these guidelines is something which have to evolve and develop as a jurisprudence for us to guide a new system. So my take on all this, let all we start thinking about a system to fundamentally change our dispute resolution mechanism using technology. Not simply go with what exists in the physical world and embrace it. That will create more problem than solution to the problems. With these words, thank you, one and all. And I must thank Justice Subramaniam, Shashank, all other team. Wonderfully executed the event. And often judges have been criticized. They're not spending much of their time for the core work. But everybody must understand here, especially those who have come, the judges in our country fit into a different role. Apart from doing a core work, a judicial judge writing judgment, they do work on Saturdays and Sundays. This is how they execute this kind of program. So now another aspect of their administration is event management. So that is, so well done, my brothers. Thank you.
Thank you, sir, for that enlightening presentation and address. To continue the conversation, please join me in welcoming Mr. Pramod Nair, who will address us on the topic Investment Treaty Arbitration and State Courts, including recent developments in state immunity in the context of ISDS awards. Please give a huge round of applause to Mr. Nair. Thank you.
Justice Karol, Justice Mustaque, Laurence, my dear friend Joongi, respected judges of the Delhi High Court, and the organizers of this wonderful and incredible conference. It's been a distinct privilege and a real pleasure to be here with all of you today. The topic that I intend to deal with is something which has special resonance for India. The topic is investment treaty arbitration and state courts. The Indian courts have been asked to engage with issues of ISDS in a number of contexts, and I think the scope of that engagement will only increase as we go ahead, notwithstanding India's attempts to denounce and terminate a number of its bilateral investment treaties, because the new generation of treaties are now being adopted. Recently, India entered into a new BIT with Israel, and I think that will probably act as the model for new treaties that the Republic of India will enter into. In terms of what I intend to cover within the limited time that I have are a few topics, which is the role of state courts in ISDS in the context of one, enforcement of awards, and there's a distinction between ICSID awards and non-ICSID awards. Justice Karol spoke about the International Center for the Settlement of Investment Disputes. The second area of engagement will be when courts are called upon to intervene to annul arbitration awards in the non-ICSID context. The third area of engagement could be when states are called upon to assist ISDS proceedings by lending their powers to order interim measures of protection in support of arbitrations that typically would probably happen outside that state. And there is, of course, one aspect here, which is whether the power to order interim measures in support of an arbitration would also include the powers of a state court to injunct and arbitration that is happening under various ISDS rules. The last element, and this is something which has been controversial in the Indian context, is whether the decisions of state courts or delays in making decisions of the state courts can engage international responsibility. And I think in the Indian context, there's the famous White Industries case. Some people would describe it as the infamous White Industries case. So let me start with that first. As a matter of international law, the state includes the parliament, the executive, and of course the judiciary. So whilst national constitutions, the Indian constitution included, has an independent sphere of functioning for state courts, from an international law point of view, the state courts are part of the state, and actions, omissions, inaction of state courts can engage international responsibility. So therefore, any conduct of a state organ, the judiciary included, can be attributed to the state and can be termed to be a breach of an international obligation if it falls into one of these categories. Then the main categories where decisions, actions, omissions of state courts can lead to state responsibility is where there could be a potential denial of justice, where a state court does not extend a fair and impartial process to resolving a dispute involving a foreign investor. This could be cases where there are delays in hearing a case, there are arbitrary procedures that are adopted by state courts in deciding matters, or if decisions are manifestly induced by corruption. There could be cases where a state court decision could result in the expropriation of an asset of a foreign investor. And in the Indian context, there was a whole avalanche of treaty claims that were commenced and in fact threatened, a lot more were threatened, in the aftermath of the Supreme Court's decision annulling or cancelling the 2G licenses. Now, the Supreme Court had its own reasons for cancelling 2G licenses that were allocated without following mandatory principles of Indian constitutional law and Indian administrative law. But at the international level, the way foreign investors characterized their claim was that the action of the Indian courts in cancelling 2G licenses after they had made their investment amounts to a judicial expropriation of an investment they had made in the country. There could also be cases where there's a denial of a fair and equitable treatment claim, where a court decision that falls short of the standard can then form the basis for an ISDS claim to be made against the country. In the context of the White Industries case, which many of you are familiar with, it was a case where India was held liable for not providing effective means for a foreign investor to assert its rights. This was a case where a commercial arbitration award was set aside by the Calcutta High Court. The matter was pending before the Supreme Court for long. The matter could not be decided because the question at that point in time was whether the Indian courts could, in fact, set aside an arbitration award rendered in a seat outside India. That's the Bhatia principle. And the Bhatia principle in 2002 continued to operate until 2012, when in Balco, the Supreme Court clarified that Indian courts could not set aside an arbitration award in a seat outside India. But till such time this matter was decided, the investor's claim to enforce the arbitration award in India was essentially stuck in limbo. The investor commenced proceedings under the India-Australia BIT and was awarded damages on the basis that the inaction of the Indian courts had deprived the investor of effective means of enforcing rights. The next area of engagement between state courts and ISDS is where state courts are often asked to intervene to provide interim relief in support of the arbitration process. And like commercial arbitration, in all these cases, there could be concurrent jurisdiction between a national court and an arbitral tribunal. So why would then an investor choose to approach a national court? Firstly, it could be because constituting an ISDS tribunal, and my friend Joongi has handled a number of cases as arbitrator, it often takes months for an arbitral tribunal to be constituted in the ISDS context. And if urgent interim relief is required, then it is then essential to approach a national court for relief. Secondly, there could be cases where interim relief is not sought against the counterparty state, but probably a third party. a tribunal's authority is limited to the parties to the arbitration agreement, which are typically the investor and the host state, whereas a national court could probably also exercise its jurisdiction over third parties who are not part of the arbitration but may be in possession or control over the assets in question, for example, a bank holding the state's assets. State courts can sometimes be approached because they have far greater coercive powers than an arbitral tribunal could exercise. For example, the power to imprison a person who is in contempt of an order is only available to a state court and not to an arbitral tribunal. In the Indian context, in addition to all of these, the Indian courts have sometimes been asked to intervene to injunct arbitrations that have been commenced under investment treaty arbitration. So, for example, the Vodafone and Khaitan cases may be cases that many of you in the room are familiar with. Vodafone was a case where different Vodafone entities commenced proceedings against India under different bilateral investment treaties, but the cause of action was essentially the same. It was the retrospective income tax amendment. As far as the Khaitan Holdings judgment was concerned, this was a case where the point that was raised by the government of India was that this was not in fact foreign investment. This was an investment made by an Indian family which round-tripped Indian funds to an offshore destination and routed it back to India, and therefore the transaction did not have a transnational flavor. It was not in fact a genuine foreign investment, and such an investor should not be provided access to a bilateral investment treaty. On that basis, the Republic of India sought an injunction from the Delhi High Court saying that the court should intervene to injunct the continuation of a BIT arbitration that had been commenced against the Republic of India. In both these cases, the Delhi High Court took a conservative view and said that it's really open for the government of India to make all these cases on jurisdiction, on abuse of process, etc., before the arbitral tribunal, which had by then already been constituted. And the Delhi High Court would not, absent extraordinary circumstances, injunct an ISDS arbitration from getting off the ground. The third and probably the more controversial area of engagement would be in cases where state courts are asked to annul ISDS awards or subject to the annulment regime, etc., sometimes to recognize and enforce arbitration awards. Here, there is an important distinction to be made between ICSID and non-ICSID awards. The ICSID system is a self-contained system. It has a self-contained mechanism for annulment. My friend Joongi will be speaking about that. As far as ICSID awards are concerned, they benefit from this streamlined self-contained system, but whereas non-ICSID awards are subject to a broader international framework with more opportunities for judicial review. And Justice Karol had spoken about the ICSID Convention. India was one of the parties which was closely involved in deliberating and adopting the ICSID Convention, but it ultimately did not sign it. And the reason it did not sign the ICSID Convention was because it wanted to preserve the role for state courts to review ISDS awards rather than have that outsourced to a streamlined, self-contained system, which is what the ICSID Convention had eventually adopted. As far as ICSID awards are concerned, I'm not going to go into this much. Recognition and enforcement is largely self-contained. It requires all states, now there are probably 160 plus states which are parties to the ICSID Convention, to recognize an ICSID award as binding and to enforce the pecuniary obligations of an ICSID award as though it were a final judgment of the highest domestic court in that country. The grounds for annulment of an ICSID award are limited. Joongi will deal with it, so I will not. As far as execution is concerned, however, this is a lot more complex because whilst recognition is automatic, the execution of an ICSID award, which is the actual attachment of assets, it could be a plane, it could be a ship, it could be money in a bank account, is still governed by the laws of the country where the respective assets are located, including its laws on sovereign immunity. And this is not overridden by the ICSID Convention, and that's expressly clarified by Article 55 of the ICSID Convention. As far as non-ICSID awards are concerned, the process for setting aside a non-ICSID award or the process for enforcing an ICSID award or non-ICSID award is largely governed by the New York Convention. So the same convention that applies to commercial arbitration awards is pressed into service insofar as non-ICSID ISDS awards are concerned. And the grounds for refusal are the same grounds that are articulated in Article 5 of the New York Convention, which is mirrored in Section 48 of the Indian Arbitration and Conciliation Act of 1996. I'll make a very few observations on the current controversies in the context of state immunity. I think Justice Karol had mentioned that a lot of ISDS awards now are not being enforced by or complied with states voluntarily. They do contest enforcement, and many of these challenges are pending. India has contested, especially the Antrix Devas awards, and those challenges are still pending, probably years after the first challenge was made. As far as state immunity is concerned, it's common for international lawyers to make a distinction between two kinds of immunity: immunity from suit and immunity from enforcement or immunity from execution. By agreeing to an arbitration clause, or by agreeing to an arbitration clause which is contained in a BIT, a state is deemed to have waived its objections as to, waived its immunity as to jurisdiction. So an ISDS tribunal can, of course, adjudicate on that issue. But that does not automatically tantamount to a waiver of immunity against execution, because at that time, a state can still make the objection that the asset against which enforcement or execution is sought is a sovereign asset. So if it's, for example, an asset of the Republic of India, which is a sovereign asset and not a commercial asset, the state can still object to execution of an arbitral award against that particular asset. As far as well, this is probably not an immunity question, but one of the questions that has arisen in recent times, especially out of the Devas cases, is can an award that is made against India in an ISDS context be enforced under the New York Convention? And there have been two views that have been taken by different courts. The first view that has been taken is that, well, this is an investment award. It's a dispute arising out of an investment. An investment is essentially a commercial activity. The investor has pumped in funds into the host state, and therefore it satisfies the requirement of commercial. And therefore, any such award can be enforced under the New York Convention. The counter-argument is that India, like many other states, has availed of the opportunity to make a commercial reservation to the New York Convention. So there are two reservations that are permissible under the New York Convention. One is the reciprocity reservation. The second is the commercial reservation. India has made both. And therefore, the upshot of that is India has only agreed to have commercial arbitration awards enforced, both within its territory as well as against it. And therefore, if the award is not a commercial award, then it cannot be enforced under the New York Convention. And the argument is that the cause of action is not really the investment as such. The cause of action is the breach of a sovereign guarantee, which is contained in a BIT. It's a guarantee made by the state to a foreign investor. And that has the character of being a sovereign guarantee, which is not a commercial activity, and therefore the resulting award arising from an alleged breach of that activity cannot be a commercial arbitration award. And there are courts across the world which have taken divergent approaches to this question. I'll probably stop with that in the interest of time, but very happy to explore some of these themes fully if any of you have any questions at the end of the session. Thank you very much.
Thank you, sir, for adding to the richness of this discussion. To add another dimension to the discussion, I now request Professor Dr. Laurence Boisson de Chazournes to take the dais and address us on the topic investment arbitration and climate change. Please give a huge round of applause to Professor de Chazournes.
Good afternoon, good evening. It's late in this room, but I would like to thank the organizers and the judges for their very kind invitation. I would also like to say that I'm very pleased to be back in Delhi and to see many former students who are doing very well in Delhi or elsewhere. It's a pleasure to see them. And a special thanks to Mr. Gav Malhotra and Mr. Arijit Sanya as well, and Mr. Arib, for what they've done to make my stay very pleasant. So in the course of the last days, we have already heard about climate change and investment. So this is going to make my task quite easy, and I'm going to be short, so to satisfy our president. What I would like to do is to give you my perspective of the topic, and so we will then be able to discuss it if you want. Now, one thing that I would like to stress when we speak about climate change is that it's not only an environmental issue. It's a social issue, it's a cultural issue, it's an economic issue. Now, when we look at the interfaces between climate change and investment, we're looking at the economic facet. And there, we know that one of the most important things to do to fight against climate change is to decrease our reliance on fossil fuel energy. We have a very heavy reliance on fossil fuel energy, and we have to decrease it. We also have to increase our use of renewable energy. And as well, I think we have also to decrease our use of energy, to learn to live in another way. So why I'm stressing this economic facet is to show that trade and investment are key parameters for helping us to change the way we're consuming energy. Now, we have heard about it. I'm just going to highlight a few points. But we know that the most important judicial body of the United Nations, the International Court of Justice, has rendered an advisory opinion in July this year, which has already a lot of resonance. It's an advisory opinion, so it's not a binding decision, but it's coming from an authority, and I would just remind our Indian colleagues that there is a judge, an Indian judge, sitting on the International Court of Justice. Now, what I think the value added of this advisory opinion is that it's a comprehensive statement of the existing law. The International Court of Justice has not created law. It has not the power to create law. It has just restated the applicable law in the context of the fight against climate change. And in this context, we know that, for example, the Paris Agreement is an important instrument, as well as other conventions, such as the law of the sea. The court has also stressed that customary international rules play an important role. Now, so the value of this advisory opinion is that it's an instrument which is shedding light on what is the applicable law. And I'm sure that the arguments based on the advisory opinion will be brought before the Supreme Court, that's for sure, in relation to climate change. What I think is important to keep in mind is that the court said, I've only been dealing with the most directly relevant body of law with respect to climate change, but the court has said that there are other bodies of law which also are relevant for dealing with climate change, and the court specifically mentioned international trade law and international investment law. So with that, what I would like to stress is that there is no opposition between climate change law and investment law. Investment law is part of the legal regime which is going to help to shape new types of behaviors. So in this context, we should speak in terms of relationship between these two bodies of law. We should not speak in terms of exclusion of one by the other one. Now, that is said, but the question is that how are we going to make sure that the standards of investment law are interpreted in a way that also satisfy the ambit of climate change, or how are we going to make sure that the rules of climate change abide to the standards of investment law? I'm just going to give 3 examples, and relying on what we have heard for one of the examples. The first one is that the International Court of Justice has stressed It's a wake-up call for states, and especially for northern states, that they have to abide to their commitments. And that means that the court has referred to the right to regulate of a state, the right to regulate and to take all the adequate and necessary measures. Now, if you look at investment law, you find the right to regulate in the public interest. And so this is affirmed that you have a right to regulate, even if there is an impact on foreign investors, but there are conditions to be fulfilled. And one of the main conditions are that the regulatory actions must be undertaken in good faith and serve a legitimate public purpose. They should not be discriminatory, they should not be arbitrary, and they should be proportionate. So we have these questions. What I wanted to highlight with this is that it seems to me that the public interest, which is enshrined in the fight against climate change, is going to give a lot of weight to the right to regulate of states in investment arbitration. And there we will, I think it's potential questions, but there will be a need to assess what means proportionality, what means necessity when we speak about a measure taken in the context of climate change. The other potential question is that should we not consider that we should make the right to regulate autonomous from other standards of investment law, such as the FET standard? Second interface, this is the fair and equitable treatment standard, the FET standard. This is, I think, a key standard in investment law. It's becoming much more important than expropriation when we look at issues of regulations in the name of, for the sake of public interest. And that has been said yesterday by other panelists, but the question is to find the balance between what a state is entitled to do in proportionality, in terms of necessity, and what the state is not able to do. And there too, the question for us is that, is there a special regime in climate change which is going to frame this relationship between what a state is entitled to do and what a state is not entitled to do? What I would like to stress with the FET is that when you assess the fulfillment of the FET standard, you look at the behavior of the state, but you look also at the behavior of the investors. And if there is a lack of diligence, that has to be taken into account. So it's an appreciation, and it's a case-by-case appreciation that has to be done by a tribunal. I would like also to mention that investors also can use the FET to sort of constrain a state to implement its legislations in proportionality and necessity, and abiding to the principle of non-discrimination. And maybe I mentioned just a case that was not mentioned yesterday, which is the Zelena versus Republic of Serbia case, where the tribunal considered that the state had not been consistent in its application of the environmental law, and there was a breach which had to be compensated. Third interface, and it's in relation to just what we have just heard, it's in relation to the enforcement of awards. Enforcement of awards by domestic courts in the context of non-exit arbitrations, as we've heard. And there, it's a question for you, but I think what is interesting for us is to wonder if all what deals with climate change pertains to what we call public policy or the public order. And could a domestic court, not satisfied by a decision and award in relation to climate change, considers that there is a breach of public policy in the meaning of the domestic law of the concerned state? So it's a question, I think, which will arise, and I would just like to stress what the court, the International Court, has said about climate change. I'm quoting the court. It said, climate change is an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. So you can feel that issues of public order, public policy are linked to this matter, and it will be interesting to see if this can be articulated in the context of enforcement of awards. So a few concluding points is to say that I agree with the panelists that now judges in the arbitrators are going to be confronted to arguments based on the advisory opinion of the International Court of Justice. But I think we should read carefully this advisory opinion because it gives some leeway for all regimes of international law to find application altogether. Now, what we know from the International Court of Justice is that states will have to take stringent measures to fight against climate change. They are not done so far. And we will see next week in New York what is going to be committed by the northern countries, but also the southern countries. And that means that they will have to make choices, and hard choices. And the big question is going to be to see how it fits with international trade law or with investment law. And for that, when we look at the standards of investment law, I think there is some space for reconciling the two issues, but there is a need to look carefully at, especially at certain standards, which are the one of proportionality and necessity. I thank you for your attention.
Thank you, ma'am, for throwing light on such profoundly relevant and urgent issue. To conclude this discussion, I now request Professor Joongi Kim to take the dais. He will address us on the topic comparison of annulment regimes under ICSID and non-ICSID cases. Please give a huge round of applause.
Thank you for the introduction. It's a great pleasure to be here. I, of course, want to thank Judge Karol and Judge Mustaque, Promote, and Laurence, of course, and the wonderful organization by Shashank and Arib and others. In the limited time that I have, I'd like to go through what Promote introduced to us. And before I begin, I'd like to begin with a little story. It's a very famous story of an old man who had a beautiful horse. It's a story from China. And one day, he lost his beautiful horse. His horse disappeared. And everyone was so sad for him. And they asked and they tried to console him, and they said, "Aren't you so sad?" And his reply was, "Well, maybe it's not the worst of news." A couple of days later, what happens? His horse, beautiful horse, brought dozens of other beautiful horses back with him. And he was so happy. Everyone was so happy. "You must be so happy." And then his reply was, "Well, maybe it's not the best of news." And of course, what happens then? His only son rides the beautiful horse. Unfortunately, he falls, breaks his leg, and has a terrible accident. And everyone is so sad. His only son has this terrible accident. And they ask him, "Aren't you really sad?" And he says, "Well, maybe it's not the worst of news." And then, of course, what happens? A war breaks out. Everyone is conscripted except his son. The moral of the story, and I'll try to link this back to what I want to talk about, is you really don't know what's going to happen in life. So I'm going to take a quick deep dive into the annulment regime that Pramod mentioned in both ICSID and in the non-ICSID context. In the ICSID context, as Pramod mentioned, it's a self-contained system by design. So who decides the annulment? There's a special annulment committee appointed by ICSID. 3 people appointed by ICSID. Parties don't get a chance. One shot. That's it. And everything under the annulment is governed by the ICSID Convention. Relatively speaking, the grounds under ICSID to annul are very narrow. On the flip side, you have the non-ICSID context, where an award, an investment award, and we're focusing on treaty awards, could be annulled. And I put in, as you note, in parenthesis, the word S in parenthesis, because as we know, when you're annulling in courts, depending on the country, you could get multiple shots because you can appeal your challenge. So it's not one shot. And where do you get to challenge your award? You challenge your award in the place, the seat of arbitration, which is what I'm going to spend some time on. The standards by which an award is annulled, potentially, will depend upon, usually, the law of the place, the national arbitration law of the particular country. And relatively speaking, depending on the country, compared to ICSID, usually they're a bit broader. So under ICSID, there are 5 major grounds, but 2, Maria mentioned 1, but usually the top 3 grounds are laid out there. Manifestly exceeded, the tribunal manifestly exceeds their power, serious departure from fundamental rule of procedure, and the award failed to state reasons. In traditional countries, well, any country, depending on their laws, there are multiple variations on this. And of course, as you see what's missing in the ICSID Convention, there's no mention of public policy. There's no mention of breach of natural justice. Some countries have a very strong view on corruption and fraud in annulling awards. When countries' courts annul awards, investment awards, they have different standards on how much deference they want to give to the award. Some will go de novo, particularly on jurisdictional issues. Some will grant the tribunal much more deference on these issues. So what I want to focus on particularly is, because even within non-ICSID investment ISTS, we have institutional arbitration, and of course we have ad hoc arbitration. Institutional arbitration, not as common, but of course leading place would be SCC, Stockholm Chamber of Commerce, and occasionally even ICC has some cases, and of course other institutions are trying to expand in this area. For institutional arbitration, it's actually clear. What's clear is what I want to focus on is the place. Because the place will determine which court gets to annul and which law applies. So then you got to figure out what's the place. But for most institutions, such as SCC and ICC, the institution will decide the place. However, for ad hoc and uncitral, it's much more complicated. So I want to introduce one leading case which kind of frames the problems, and this was the famous Philip Morris case. Everyone, of course, looks at the Philip Morris case from other angles, but there's one very interesting thing that happened in the Philip Morris case was how to determine the seat, the place of arbitration. And there were basically 2 options that the tribunal faced and the parties. One party was advocating for London, and one party was advocating Singapore. And this choice actually becomes quite significant. So then the question is, how are you supposed to decide between the 2? So this was an uncitral case. There was a bilateral investment treaty between Hong Kong and Australia. Didn't really say anything about this. So tribunal is stuck with the uncitral rules. And what do they say? They say, having regard to the circumstances of the case. What does that mean? We do have the uncitral notes, and I'll elaborate that, but the most commonly cited guide on this issue is from a NAFTA case between Ethel versus Canada. And they outline 5 factors for this. And these are the 5 factors. First is the stability of the law, the arbitration, and judiciary. So between London and Singapore, they said, they have robust judiciaries, they have solid, well-tested arbitration laws. There's a tie there. Number 2, treaty on enforcement of awards. Of course, Singapore and UK, both members of the New York Convention, there was a tie there again. Number 3, convenience of counsel and arbitrators. This is a factor in determining the seat of an arbitration, the convenience of the counsel and arbitrators, particularly the distance that they have to travel. So they were weighing this, and relatively speaking, because of course a lot of the counsel were in, I believe, in the UK and in Singapore, they ended up relatively felt that it was more convenient to be in Singapore on this issue. This issue actually kind of turned the tables. 4th issue was the availability and cost of support services. And this simple thing would be things like hearing facilities, transcribers, interpreters, things that support the arbitration. Here, of course, this was a closer call between the two jurisdictions. And the last one was the subject matter of the dispute. Of course, this had to do with the plain packaging. That was the big issue. Australia was regulating how the cigarettes would be packaging. And where was that? Of course, this tends to always be the state. Now, a couple of other interesting issues that they did cite was the relative connection to the dispute and whether it was centered in Australia. And here, they felt it really sided with Singapore, because Philip Morris technically sued under the Hong Kong Australia BIT, so technically they were a Hong Kong investor. So you had a Hong Kong investor and Australia as a state, relatively much more closer to Singapore. And the last issue, of course, something probably no one ever thought about at the time, was this case was under the PCA. And of course, the PCA has these host country agreements with countries all over the world. And it happened to be Singapore being so pioneering, they signed hosting agreement with Singapore. But the UK did not have this. This, again, tilted the tables towards Singapore, and they decided Singapore will be the seat. So I was looking at, of course, one of the most current India UAE BIT. And of course, here, the model BIT, but the India UAE BIT cites two factors actually. And one is the convenience of the parties, that's something we saw. And the second one is the location of the subject matter and proximity. Again, that's something we saw. But what's missing is the third one, which actually exists in the model BIT, which is a special consideration for the capital city of the defending party. That one was taken out. I would presume this was because UAE proposed that, and India agreed. Now, putting all this into perspective, there's a hotly debated, controversial case, two cases, very closely related facts that were brought against Korea. And again, the first one was Mason versus Korea, and Korea lost both cases. First one, the place of arbitration was decided as Singapore. Now, this is the irony of the case. So technically, they agreed on Singapore. And of course, what happened was, in that case, Korea lost. They tried to challenge. Because it was seated in Singapore, the Singapore International Commercial Court, SICC, reviews the award. And Korea tried to challenge on a jurisdictional, I won't get into that, but the court said, nah, we don't buy that. So Korea lost in their challenge, and they gave up on this case. Now, the interesting one is the Elliott case. Very similar facts. This one was contested. Initially, Korea wanted the place to be Singapore. And of course, Elliott wanted it to be London. After much debate, we don't know why, as we don't have an explanation, but they settled on London. So at that time, like that moral of the story I told you earlier, Korea was very sad. You wanted Singapore. But what happened in this case is because they were in London, and very recently, the first level High Court had ruled against Korea on that jurisdictional issue, but the Court of Appeal just recently reversed. The stroke of fortune, at the time, Korea was very, very disappointed that they were stuck in London, but now they're very happy that they're back in London. So, to wrap things up, as I suggested, from you, of course, the parties, the investor usually gets this choice. But whether you go to ICSID or whether you not go to ICSID is a fundamental choice. There are pros and cons both ways. One would tend to think if you're an investor and you're really confident in your case, you think you're going to win, then you probably want to go to a place where there's not a real chance to get annulled. And as we saw, relatively speaking, ICSID is much more difficult. One shot, and I explained all that stuff. So much more finality. Other side of the table, if you go to the non-ICSID world, then of course, again, pros and cons, might be confidence in the merits. You might think that you were going one place or the other, but roll of the dice, you might end up in a jurisdiction that you didn't expect. But things could turn out to your benefit. And that's kind of the moral story. So when you're actually choosing counsel, because location of counsel is also a factor, it actually influences the choice of the seat. So you might think you want London counsel, but by choosing London counsel, that could actually run against London being a choice of the seat. And of course, they don't think like that when of course, you want the best counsel, but this is something that actually comes up at the end. Thank you so much.
Thank you so much, sir. Ladies and gentlemen, please join me in thanking our chair and the distinguished speakers for their insightful contributions with a warm round of applause. Now, although we're hard-pressed for time, but in the interest of the topic and promoting dialogue, we will open the floor for a couple of quick questions. I will urge you to keep the questions brief, please. I see one hand back there.
Before you start with this question and answer session,
So please.
we have both my colleague and I, we have offered, and our guests from abroad have agreed that most of the questions can be answered by them. Thank you. And the one who travels abroad frequently.
Good evening, ma'am. My question is to Professor Laurence. Ma'am, you were talking, am I audible? So my question is, you were talking about proportionality and necessity. Now, how do you balance this when the climate policies are very different? For example, if you look into the European standards, they have a very high standards. And when it comes to India or any global south countries, it is lower. And besides this, if you look into the American environmental policies, it has changed very much with the coming in of the Trump administration. So how do you address these issues?
It's what I think I didn't well understood your question, but you were speaking of the standards of investment and the content. But this is, I think, a story for different fields. Though there are standards which are defined, but also indeterminate, and it depends very much on the situations. Yesterday, we heard that the facts are very important for appreciating the fulfillment and the respect of a standard in a certain case. I think for me, what I wanted to sort of stress is that a lot of these standards are sort of shaped by notions of proportionality, non-arbitrariness, and non-discrimination, and so on. And this might be in relation to these standards that there is some thinking to be made about how to understand better how they are complied with.
Thank you, ma'am. And with that, we've come to the end of today's session.
I have one question, if I may.
Okay, we'll take Arib's question first, and then if the time permits, sir, I will pass it on to you.
I'm
Yeah.
Garv.
Sure, sir, sure. Arib, if you can pass on the mic after you.
So I'm Garv Malhotra, and I have one question. That we spoke about UNCITRAL and ICSID 2 regimes. Does it still make sense for countries who've watched on the sidelines and decided not to sign the ICSID convention to revisit that question maybe every once a couple of years?
I think probably the interesting example would be Ecuador. Ecuador, of course, denounced their membership, and then they rejoined subsequently. As was explained, we have, I think over 160 countries that are members of ICSID. And as Pramod explained, India was initially a country that was well involved in the negotiations. So again, there are definite benefits from the government perspective. Do you want to be part of this self-contained regime? It's statistically, they would suggest there's no benefit to either investor or state. Both sides, basically, statistically, have prevailed in half of the cases. So there's, and of course, another thing I think that benefit that ICSID provides, it's a training ground for future Indian arbitrators and counsel to be part of the system. You have, of course, people being involved, but I think it's a direct way they can be appointed as arbitrators on tribunals and, of course, on annulment committees. And that's a definite way I think that could contribute. What do Indian investors want? Will this bring a lot of more cases against India? I guess these are all the factors that countries like India have to consider.
Thank you, sir. We will take one last question. And sir, I would urge you to please keep it brief.
Sir, my name is Swandakara. First request is to DAW that today's presentations were excellent. We couldn't note down much of it. If that can be shared, yeah, I'll ask that. My question is to Dr. Laurence. We start with the Paris Agreement, you started with it. Article 2 talks about 1.5 and 2 degrees centigrade. It should not be breached. But what was the base year has been only clarified after 5 years of the agreement, that is the pre-industrial area. By the time half of it, 1.5 had already been broken. Then we come to Article 6.2 and 6.4, where we talk about carbon accounting and those things. Then we come to Article 11 and 14, which talks about NDCs and other things. I'll go back to what you were talking about, that the energy part of it, that comes, in fact, the Paris Agreement doesn't talk about anything only about the temperature. It doesn't say what is the source of increase in temperature. We are only insisting on energy. That comes under SDG 7.
What is the, sorry.
My question, I'll come to, let me explain her where I'm coming from. You are only talking about energy which is trying to breach the 1.5 and 2 degrees centigrade. What about SDG 16, which talks about peace and war? That is the thing. Even the new president has announced that $250 billion were given for war by USA and $125 million by the EU. So isn't that breaching that 1.5 and 2? And after this ICJ ruling, where would those countries go? If you look at the NDCs of GCC countries where we are talking about the energy part of it, their NDCs are credit in green. UAE has purchased green credits from Zimbabwe worth $2.6 billion, which is more than the GDP of Zimbabwe. And now, where would these countries like Kiribati, who had approached United Nations, which country they would go to? Because the maximum emitter is USA, China. So where would they go?
Thank you for your comment. It would take us quite far, but I think that we should also stress that the Paris Agreement is built on sort of voluntary commitments. So we have a first phase of voluntary commitments which have been made. They appear not to be sufficient if you look at the target of 1.5 degrees Celsius. Now, the question, and this is going to be dealt with next week in New York and in Brazil, is how to make pressure on states to commit more. And I'm speaking mostly of northern countries, but also of China and big countries which have a responsibility. There is this principle of common but differentiated responsibilities, which is very important. There's also the principle of equity, which should be taken into account. But we are, and I would like to end with that, when we speak about climate change, in fact, everything started in the early 90s. So it's a rather young body of law, but we are also dealing with an issue which is an issue of survival for all of us. So let's make the best of what we can do. Thank you.
Thank you so much, ma'am. Before we part ways for the day, I invite Honorable Mr. Justice Sanjeev Narula, Judge of the Delhi High Court, to felicitate our chair and our esteemed speakers with the token of our respect and appreciation by presenting them with a Prabhavali. A Prabhavali is a traditional ornament arc crafted in intricate brasswork, symbolizing India's rich heritage of craftsmanship and cultural expression. Set against a backdrop of hand-woven Indian textile, it reflects the country's enduring traditions of artistry and design. We hope it serves as a meaningful reminder of your time at the Delhi Arbitration Weekend 2025 and the timeless elegance of Indian craftsmanship. On behalf of the Delhi Arbitration Week and the Delhi International Arbitration Center, we extend our sincere appreciation to you, our audience, for your time and engagement. Your presence has enriched this session and strengthened the dialogue on advancing India's arbitration ecosystem. Thank you so much.